joining up data security, consumer protection and data privacy. So over to David, Evana and Genevieve.
Thanks so much, Kayleen, and I don't think anyone could have said it better than Ed about how wonderful this event is and the centre as well. So I will let him say that on behalf of UTS, but thank you for all of the fantastic organisation that has gone into today, and we are delighted to be presenting as part of this fantastic lineup. Next slide, David. I would also like to acknowledge the traditional owners of the land. So I am lucky to be here at UNSW today. So the traditional owners of this land are the Bedegal people, but at UTS we also acknowledge the Gadigal people of the Eora Nation, upon whose ancestral lands the UTS campus stands, and pay our respect to elders past and present. Next slide, David. So, as some of you are aware, the three of us are very lucky at the moment to be working on a research project that's been funded by the Australian Communications Consumer Action Network, commonly referred to as ACAN, and we have been working hard on this for the last 2 years and have recently published a draft report in January 2022, which contains 26 recommendations which result from our research into the implications of Internet of Things devices in the home for data security, consumer protection and data privacy laws. And we've had a good introduction to the general topic area in Elisa's presentation last night, talking about smart things, and also a really fascinating sort of counterpoint from Stacey Ann looking at the American perspective about some of the issues that we look at resulting from the overlap between privacy and security law and consumer law. So the presentation today addresses our final recommendation that the principle of joined up regulation should be applied across regimes that regulate device security, including any sui generis security law, consumer protection law and data privacy law. What we do in our report is use a series of case studies of Internet of Things devices that you find in the home to illustrate problems that resulting problems with data security, consumer protection law and data privacy law. The case studies include several devices you might expect to find in a so-called smart home, including a Roomba vacuum cleaner that maps your home so it can be remotely programmed to vacuum the house, smart light bulbs that can be remotely controlled or programmed using an app or a smart assistant such as Google Nest, an August smart lock that can be unlocked through an app or a smart assistant, and a Ring video doorbell that allows owners to see who is at the door on their linked device. So I am now going to hand over to my colleague, Dr. Evana Wright, who will explain how the Ring video doorbell engages data security, consumer protection and data privacy laws that are not currently joined up, raising a series of issues for consumers.
Thanks, Genevieve. So Ring is a US-based company that's now owned by Amazon that provides a range of home security devices and services, including video doorbells, security cameras, and home monitoring plans. And as part of our case study, we've really done a deep dive into the terms and conditions that govern the use of these kinds of devices. And in the case of Ring, there's a whole suite of legal terms and conditions and policy documents that govern the use of Ring devices. And through the case study, we've identified a number of issues in relation to acceptance of these contracts, data storage and usage, the way in which the software can be updated and the product essentially changed without consent, and issues around consumer protection, particularly in relation to warranties. But one of the things that came out of our research into Ring were the Ring class actions complaints that have been brought in the United States dealing with data breaches and the Internet of Things devices. And these class action complaints that have been filed in California are really illustrative of the intersection between data privacy, security, and consumer protection. So the first of these cases is a complaint by John Baker Orange on behalf of himself and others against Ring and Amazon. And this complaint seeks relief for negligence, invasion of privacy, breach of implied warranties of merchantability, breach of implied contract, unjust enrichment, and violation of unfair competition law. And in this case, the plaintiff's outdoor camera was hacked, with the hacker speaking to the plaintiff's children. And the complaint actually outlines several other examples of unauthorised access to Ring devices. And the case, or the complaint, alleges that Ring failed to implement basic security measures such as strong passwords and two-factor authentication. And these are security standards that are common to most of the major security standards that are put forward for IoT, including the ETSI standard. The complaint in this case alleges that as a result of failing to require these security measures, that the Ring cameras were unfit for ordinary use and weren't of merchantable quality, but they also resulted in a breach of privacy in that hackers were able to access the home, access information about the plaintiff's account as well. Interestingly, following these complaints, Ring has actually updated its encryption and security policies so such that data is now encrypted at transit, in transit and at rest, and that two-factor authentication is now an option. However, Ring has noted that using some of these enhanced security measures may actually reduce functionality of the product. Another example is the LeMay complaint, again in California, and again seeking relief across a vast range of laws, including negligence, Californian unfair competition law, contracts for breach of implied contract, unjust enrichment, and privacy. And again, this complaint dealt with the use of Ring products in the home and various disturbing events such as hackers obtaining access to cameras and speaking to the occupants or playing music. In one example, a hacker accessed the video camera in a child's room and began speaking to her, saying that he was her best friend, asking her to engage in particular behaviour. In other examples, hackers threatened users and demanded ransoms to be paid in Bitcoin. And again, the complaint dealt with Ring implementing appropriate security measures such as two-factor authentication and notifying a user when the account is accessed from an unknown device. And it's actually really interesting because Ring devices are seen as unknown as vulnerable to hacking. There are many forums online, including Discord, and Nullcast, a podcast that actually document how you can breach these the security settings on these devices. So the argument is that Ring is aware of these security defects and that they're therefore not fit for, they're not merchantable quality, they're not fit for purpose, and that there are obviously privacy implications. So I'll hand over now to David to talk about how principles of joined-up regulation, and in particular privacy, security and consumer protection, could provide better protections in this case.
Okay, thank you, Genevieve and Evana, and I'm sorry that I can't be there in person this morning. I had some other teaching commitments. And the logistics just didn't work. So I'd start by making the point that this is work in progress, and we very much would appreciate feedback on what we've produced, which is quite a substantial draft report, as Genevieve mentioned, with 26 recommendations. And what we're doing today is merely just one part of the report. Transformative technologies such as IoT can disrupt laws, resulting in laws and regulations that overlap and inconsistent or misaligned laws. One reason for this is that laws and law reform processes are based on pre-existing legal and policy paradigms, each with their own rationales that do not readily apply to new and emerging technologies and business practices. The current wave of technologies are based on the mass collection, analysis, and use of data, but there's clearly no set of coherent principles or laws that apply to these processes. Instead, we have a patchwork of laws with diverse objectives, which were designed to apply to previous generations of technologies and which sometimes overlap, but in general are ill-suited to regulate current and emerging technologies. Now, our project focuses on the problems that arise with the application of security, privacy, and consumer protection laws and rules to consumer IoT devices, focusing on devices in the home. The proliferation of consumer IoT devices is really a step change in the data-centric business model that has underpinned the digital economy. That model, as illustrated by the practices of digital platforms, involves collecting data about consumers at scale, which is analysed and used for targeted advertising or indeed for other dark practices. IoT, as cyber-physical systems, goes further. It involves ubiquitous collection and processing of data as integral parts of IoT devices and with effects which may be cyber or physical. Moreover, as the devices are connected, they commonly involve continuous data collection and software upgrades capable of altering functions, such as by adding or disabling features. The always-on connected nature of smart devices, together with their limited processing power, makes them highly vulnerable to security breaches. Moreover, as the collected data is often personal and may be extremely sensitive, the devices expose consumers to privacy breaches. In addition, the devices are often complex, making it difficult to diagnose and fix a problem when something goes wrong, which can raise complex consumer protection issues. Overall, these features of the devices reinforce the extent to which security and data privacy have become absolutely central to consumer protection. On the other hand, the protection of consumer data extends beyond traditional consumer protection law to include protecting individual privacy. Protecting purchasers and users of smart devices therefore cuts across the categories of security, consumer protection, and privacy laws. As Hellberger and her co-authors made the point way back in 2017, with the integration of more and more data into consumer products, many data protection issues also become consumer issues and vice versa. The application of multiple regulatory regimes to the same subject matter can be illustrated by the regulatory challenge of properly securing consumer IoT devices. As many of you know, in 2020, the Australian government released a voluntary code for securing consumer smart devices with 13 principles broadly drawn from the equivalent UK code. But a discussion paper released by Home Affairs last year reported significant but not unexpected problems with uptake and implementation of the security code. The discussion paper raised the possibility of following the UK, which last year introduced the Product Security and Telecommunications Infrastructure Bill, by legislating to mandate security standards. Meanwhile, the data security principle in APP 11 of the Privacy Act requires that APP entities holding personal information take reasonable steps to secure that information. While the review of the Privacy Act being undertaken by Attorney Generals has recommended reforms to clarify the principle, such as by giving examples of what might be reasonable steps. So far in the Privacy Act review, there's been no consideration of how to align APP 11 with other security standards, such as the Voluntary Consumer IoT Code. Turning now to consumer protection, the Australian consumer law includes the consumer guarantee that goods must be of an acceptable quality, which includes that they're reasonably safe and free from defects. The consumer law also includes a guarantee to take reasonable action to provide spare parts and repair facilities. There are, however, considerable uncertainties about how the guarantees apply to consumer IoT devices, and especially to the security vulnerabilities of those devices. While last year's Productivity Commission report on the right to repair recommended introducing a new consumer guarantee to ensure that consumers have reasonable access to critical software upgrades, including security patches, this falls short of a guarantee that smart devices are appropriately secured. Now, in our draft report, we suggest filling what we see as a gap in consumer law by introducing a new guarantee requiring connected devices to be reasonably secure. So current law reform processes are occurring largely in policy silos of, for example, cybersecurity reforms, privacy reforms, consumer law reforms, and reforms to repair rights. And yet, the need for holistic cross-sectoral reforms is apparent from the case studies introduced by Evana, and not to mention the precedent set by the ACCC's Digital Platforms Inquiry and the ongoing ACCC work on the regulation of platforms, which does recognise the importance of cross-sectoral issues, including consumer protection and data privacy. But law reform can no longer confine itself to policy silos, with processes that take little or no account of the interlinkages between ostensibly distinct legal and regulatory domains. Let's look a little bit more at the relationship between security, data privacy, and consumer protection laws. There is, of course, a lot of terminological fuzziness here, and each of these are contested concepts, but we think in essence that data security, at least in this context, is about securing techno-social systems that collect, process, and store data from unauthorised access. Data privacy is about protecting the data autonomy of individuals or informational self-determination. And consumer protection is essentially about protecting consumers from unfair transactions involving consumer products, including ensuring the quality and safety of consumer products. So there's overlapping laws and there's different policy rationales. There are, we think, three possible ways of addressing the challenge of overlapping laws. First, the distinctive objectives of existing laws could be accepted as valid, with the laws working in parallel, and inconsistencies or misalignments simply accepted as a necessary byproduct of traditional legal silos. And this is hardly unusual in the law. But among other things, this creates uncertainty and costs for business and consumers alike, and risks that laws don't achieve their objectives. Secondly, attempts could be made to achieve greater consistency between laws, such as by cross-referencing the data security principle in the Privacy Act to other security standards, such as standards for consumer IoT devices. On this approach, the legal silos could be regarded as complementing each other, with potential inconsistencies minimised. On the other hand, there can still be gaps in the law, inconsistencies between the rationales for the laws, and for consumers that suffer harm, questions about which regime should be pursued to seek redress. On the third possible approach, an attempt could be made to formulate common principles cutting across legal silos. For example, recognising the central importance of data in the digital economy, a common set of principles could be established to regulate all data collected from consumers or consumer devices, regardless of whether or not the data is personal information. This would, needless to say, give rise to questions about the purpose of regulating consumer data, what might be sought to be achieved by this sort of omnibus regulation, but we think that if we accept that consumers have an interest in all data that's collected from them or from their devices and not just personal data, this is a debate worth having. As far as achieving better alignment between the laws is concerned, in the short term, we favour reforms that focus on harmonising existing laws, such as establishing common standards across security, data privacy and consumer protection laws. Over time, however, we consider there's merit in working towards common principles that apply to contemporary data practices. One aspect of this could be to establish principles that apply to all consumer data, in effect a new general consumer data law that goes well beyond the consumer data right regime, but perhaps is ultimately where that regime may be heading, although we are not endorsing all elements of the CDR regime. There are many issues that would need to be resolved to move in this direction, including what the principles might be. Clearly, data portability and interoperability are part of this, but much more. And the sorts of regulation that might be appropriate raise real questions, as well as the relationship between consumer data law and existing data privacy law. But we do think this has potential to establish a legal framework that's equipped to deal with the commercial realities of the digital economy. But reforming substantive law can only ever be part of the solution. Reform of regulatory institutions is also required in order to ensure consistency in regulatory practices. In the UK, a digital regulation cooperation forum was established in 2020 to promote greater cooperation between the competition, privacy and communications regulators in regulating new technologies. But a report from a UK parliamentary committee back in December last year doubted if this was enough, favouring an independent statutory authority. And in Australia, there are already established mechanisms for coordinating the activities of regulators, including the Memorandum of Understanding between the ACCC and the OAIC on the consumer data right. And a digital platform regulators forum was established recently involving the ACCC, OAIC, the ACMA and the E-Safety Commissioner. And there are, of course, other less formal forms of cooperation. But what we think is missing is a dedicated expert body that proactively investigates the social and legal implications of powerful new technologies. Such a body could implement forward-looking practices, including horizon scanning, promoting the use of appropriate RegTech, and harmonising technical standards and legal rules, as well as proactively identifying gaps, inconsistencies, or misalignments in existing laws. In this way, what's sometimes known as the problem of joined-up regulation might be addressed. Now, this sort of proposal is hardly novel. Last year's Human Rights Commission report on human rights and technology that Ed was responsible for recommended establishing a new AI safety commissioner. But we suggest it's necessary to go beyond this, as AI is but one of many emerging technologies, often with interrelationships, with immense social implications. And as the example of the patchwork approaches taken to regulating the security of consumer IoT devices illustrates, this isn't a matter of regulating for the sake of regulation, but of better harnessing scarce resources to proactively identify problems, avoiding what's become the endemic practice of retrofitting laws only after problems have emerged. To reflect the theme of the conference, the legal challenges of the cyber-physical world, law reforms needed to better align laws with the realities of cyber-physical systems, such as IoT devices, and some institutional reforms needed to avoid the problems of silos and promote joined-up regulation or holistic responses to the challenges of data-centric technologies and business practices. And we've kept to the time.